Appeal, Suffolk Coastal District Council, Hopkins Homes and Richborough Estates Partnership and Cheshire East Borough Council.
Mr. Lockhart-Mumry.
My Lord, I have 4 topics to get through in a very short time. The 4 topics are a brief review, only so far as necessary, of the Suffolk coastal policies, then a brief word on the limits point, issue 3, a brief word or so on the significance point, issue 4, and, my Lord, there is at the bottom of all this an issue of discretion raised by the appellants, and I will seek guidance when I get there as to how my Lords would wish me to deal with that. My Lord, in relation to the Suffolk coastal policies, there was discussion yesterday as to the review of these policies that's foreshadowed expressly in the plan itself, and I gave, particularly to my Lord Carnwath, some comment in relation to that from the local plan inspector's report and some numbers, and my Lord asked for the extracts that made good that point. My Lord, we have circulated, and I understand it has a green tab attached to it,
Yes.
a 4-page document. I should say that Mr. Kingston has advised us that he would wish the court to see the whole of the inspector's report. For our part, we do not think that's necessary or appropriate, and I'm going to leave Mr. Kingston to make that application or objection as he will. Perhaps I can just refer my Lord
I hope
to...
that it can be done in EU form rather than having an enormous bundle of paper.
Well, my Lord, several more trees have been felled overnight, I'm afraid, and they're here in paper copy if necessary. For my part, my Lord, can I very briefly, I hope you have this document, top right-hand corner, dated June 13, issue 2, whether the overall level of housing provision and its distribution are justified and appropriate, and I'm going to take this very quickly, if I may. Paragraph 32, line 6, is the figure that I gave yesterday. That's to say that the plan was based on providing 7,590 dwellings.
Yes.
There's then reference to what the framework says about the importance of meeting objectively assessed needs. 33, 4 lines from the bottom, there'd been a recent study which identified 11,000 extra dwellings as necessary to meet the need. Penultimate line, but, said the district, that the plan should not provide for this scale of development at this stage. My Lord, over the page, please, 46, under overall conclusions, the inspector concludes in the first sentence that the scale of housing provision proposed falls substantially short of the objectively assessed need. 4 lines from the bottom, some way short of the 11,000 dwellings required, and then he debates with himself as to whether to effectively abandon the plan, abandon the examination, or, because of the importance of having a plan in place, whether he should move to encourage the council to adopt the plan, defective though it was, subject to express incorporation of the need for an early review.
But that's very helpful, isn't it? Because it shows how you can get a plan which is approved very recently, and yet one element, the element relating to housing, supply of housing, is out of date.
Well,
you don't need paragraph 49 to tell you that.
You don't.
That's what it is.
As it happens in that case, my Lord, but although it's not the battle, as it were, that's going on in these appeals.
But I wonder whether it shouldn't be, because I mean, the obvious reading of supply of housing in paragraph 49 is by reference to paragraph 47, which tells you what the objectives in relation to housing are. I would have thought that you look to see whether your housing policy actually provides for the supply in accordance with the objectives. If it doesn't, then you can say it's out of date. You then go back to paragraph 14 and see whether other policies or whatever are sufficiently serious to outweigh the need for housing.
My Lord,
That's
yes.
a good old conventional approach.
My Lord, yes, but I mean that arises in this case for the reasons I've just identified. It doesn't arise in every case, and the purpose of paragraph 49 is the deeming provision
But you say that. I don't know. I don't know why you need to. I mean, it seems to me that if the plan fails to achieve the objectives, then it can be described as out of date, and you then go back to the presumption. Why do you need to interpret it in any other way?
You don't on the facts as I've just presented them to them, which happen to show what they do in this case, my lord. But you can have up-to-date plans that don't have the need for a review, whose housing provision policies are up to date. And the Secretary of State, as a matter of policy, has introduced paragraph 49 with its interaction into paragraph 14, that notwithstanding that.
Yeah, anyway, we got that, but for your purposes,
for my purposes,
approach is quite sufficient.
For my purposes, the approach would be quite sufficient, although it's not the way that these appeals are constituted. But, my lord, I take the point. Yeah. My lord, can I go to the point in the appeals, and can I just ask the court, please, to take out the appellant's case, written case, in the core volume, page 128, paragraph 7a, and the appellant say, for the purposes of this written case, the following definitions are adopted. A, narrow, policies whose subject matter
Sorry,
is...
give me the page again.
128, my lord, in the core volume.
These are the three options.
That's right, my lord. And I'm just focusing for my submissions today on A, narrow,
Yes.
policies whose subject matter is the number, amount and distribution of new housing development. Yes. Now, my lord, I have spent some time yesterday in arguing for the wider approach in relation to paragraph 49. Hopkins doesn't actually need to do so. Hopkins can and should succeed, my lords, even on the narrow approach. And can I, for that purpose, take the court to the Authorities, volume 4B, tab 51, the plan in Suffolk Coastal, adopted July 13, well, page 2426, as I will demonstrate as shortly as I can, my lords, we have in this well-constructed plan a series of interlinking or interlocking policies which deal with the amount and distribution of housing. Page 2426, policy SP2, housing numbers and distribution, the figure of 7,900 in the first paragraph. Next paragraph, land for new homes will be distributed in accordance with the settlement hierarchy, SP19, which I'll come up to in a moment, which is itself drawn up on the principles of sustainable development. At the bottom of that box, we have the entry, the point about the review that we've covered. Page 2427 opposite, please, 3.37. The following two tables summarize the settlement hierarchy and the distribution and anticipated sources of new homes within it. The detail can be found in section 4, the spatial strategy. Just jumping ahead for a moment, the policies that are at issue in this appeal, the Hopkins appeal, are in section 4. I'll come to them in a moment. Table 3.3, proposed housing distribution. Can I just ask you to go to the third line from the bottom, new housing allocations, and the penultimate column, rest of district. You'll see a blank, in other words, a zero. So in other words, in relation to areas such as the Hopkins site outside a service centre and in technically countryside, a zero provision. Well, can I go to 2458, the housing and amount and distribution policy we've just looked at specifically directed us to the strategic policies SP19 and others. Here we've got SP19. The identification of a settlement hierarchy is a key tool with which the Council will achieve its vision, meeting the scales of development and so forth. Next paragraph, the settlement hierarchy is set out below and amplified in the accompanying policies SP 20 to 29, as well as tables 4.1 and 4.2, will be used in determining the scale of development appropriate to a particular location. So plainly we have a supply of housing and where that supply is to go, amount and distribution, to use the narrow label. My Lord, then we get to SP 19 and the tables that follow, just for reference, my Lord, page 2460, third box down, key service centre, so that the court sees where we are, settlements, a long list of which the last is Yoxford, that's to say within the settlements. Then
Sorry,
we
which
get
page is this? I beg your pardon.
2460.
page 2460, my Lord.
Thank you so much. Yep. Yes, I see. Yep,
Thank you. Then we get table 4.2 on page 2461, scale of development appropriate to each tier. Page 2462, key service centres, of which Yoxford in its boundaries is one. SP 27, we'll come to that in a second. Second paragraph, within the defined physical limits, development, including modest estate development. Page 2463, countryside at the bottom, SP 29, one of the other policies, engaged no development other than in special circumstances. So, my Lord, the amount and distribution of housing in this plan gets us to where Hopkins' site is. It is technically in countryside because it's outside the limits, and there shall be no amount of housing distributed to the Hopkins site under the strategy of this plan.
So SB 19 taken as a whole is a, quotes, policy for the supply of housing in the sense that it deals with the distribution of it.
Lord, I'm saying all of them are, when one reads them as they are expressly constructed.
Well, we're dealing with SB 19 at the moment, that's your
But
point.
SB 19, my Lord, yes.
So SB 2, yes, SB 19, you say yes.
Yes,
Right.
and then we saw in a moment ago on page 2462 a reference to SP 27. Can I go to SP 27, which is at page 2481?
Yep.
Key and local service centres, my Lord, that includes Yoxford within
Of course.
its limits.
Yes, yes.
B, permit housing development within defined physical limits. So that's how the amount and the amount of housing is to be distributed within centres. Of course, that is not the Hopkins site. And we go to page 2482, the countryside, at the bottom of the left-hand column. The countryside is defined as all of the land that sits outside the physical limits boundaries of, including key service centres, and SP 29, the countryside, is an important economic, social and environmental asset. The strategy in respect of new development outside physical limits is that development, I'm dropping down, will be limited to that which of necessity requires to be located there and accords with other relevant policies. So in other words, estate development such as proposed by Hopkins is not to be permitted in countryside, and that was why the inspector, misdirecting himself, we say, as to the terminology of paragraph 49, found that the proposals did not accord with these policies. So, my Lord, that's the structure of these policies, which, as starting at SP2, are all to do with the amount and distribution of housing. Lord, can I next go to the decision letter in Hopkins, which is in various places. Can I take it from the core volume, please?
Yes.
The letter starts at page 347 in Appendix Part 1 in the core volume, page 347, decision letter dated 15 July 14, Yoxford. Paragraph 6 on page 348, the inspector addresses paragraph 49 and paragraph 14 and has regard, 3 lines from the bottom, to the judgment of Mrs. Justice Lang in William Davis, my lord, which is in the papers, in the authorities, where the court held that paragraph 49 related only to policies which specifically dealt with supply, not distribution, but supply, which subsequent cases, including the Court of Appeal in this case, has held to be a misdirection. Obviously, this inspector, having cited to him, having reminded himself of the submissions made in 6 about William Davis, he then addresses the policies in the case. And
It's not been very easy for the inspectors, because each time you get to an inquiry, another High Court judge has expressed another view, which you then faithfully have to apply until the next judge comes along.
Well, Lord, that's a very fair point, because as we now go to each housing inquiry, we seem to carry electronically or otherwise an absolute shed load of these cases, and it does make life difficult.
And deciding which at any one time is the governing guidance.
And it evolves very regularly, almost month by month, if not more often. And it is difficult for inspectors, and I hope they get clear guidance from us when dealing with it. But it is a problem. My Lord, paragraph 8. Second sentence, line 3, he addresses himself to SP2. He does say that's a relevant policy for the supply of housing because it deals with amount per William Davis. And then SP15, SP19, SP27, my Lord, I won't read them. They're set out in the Court of Appeal judgment and in our case. But the inspector finds in each case that they are up to date, applying, we say, a misdirection as to the meaning and effect of paragraph 49. Then paragraph 13, I'll come to in another context, but he deals under the heading there, principle of the proposed development outside the defined village. I go to 13 in particular, though noting, please, 12. I go to 13. The appeal site is outside the physical limits boundary as defined in the very recently adopted local plan. And then SP27, he addresses, and 14, second sentence, please. The proposed development will be unacceptable in principle, contrary to the provisions of SP27 and SP29, and contrary to one of the core principles of the framework. And then, having dealt with other factors, and this is perhaps a point that touches on discretion, but can I go to page 353? In the planning balance, the inspector in 31 has regard to the positive aspects, housing and affordable housing. In 32, however, I found significant conflict with policies in the recently adopted local plan. I've also found conflict with some saved policies of the old local plan. I've sought to balance these negative aspects against its benefits. I consider the unacceptable effects are not outweighed by any benefits, and so forth. My Lord, the Court of Appeal addressed the manner of this decision in paragraphs 52 and 53 of its judgment. I won't go there in the interest of time, but we commend respectfully those paragraphs as a correct assessment of the position. Lord, that is subject to any intervention by the court. That is all I'm going to say about how the Suffolk coastal policies are policies for the amount and distribution of housing, and they all link the concomitant policies to the amount and distribution of housing. I'll come to issue 3, if I may, which is the very much shorter issue of the village limits, the development limits of Yoxford, and this has really been pretty well trodden in the hearing up till now. I mean, the facts are that these limits were defined in 2001. While they may have been tinkered with elsewhere, they had remained unchanged in Yoxford for all the years up to and including the decision, and indeed to date. They are, as the plan itself says, and my learned friend Mr. Clay has confirmed, they are under review. They were under review then, they are now under review. Point 2 on limits, the MPPF places great emphasis on the importance of plans being up to date. We see that, of course, in 49 and 14, which are particularly engaged by these appeals. It can be seen throughout the framework. Can I just list, for the present purposes, paragraphs 12, 17, first bullet point, 184, as some examples of the importance placed on policies being up to date.
But I mean, surely the point here is not really the date as approved. I mean, you know, in this one sense, the fact that a plan has been carried through in the plans consistently for 20 years is something which might give it more strength. The important point here is not when it was approved, but the fact that it was under review, isn't it?
Well, my lord,
I mean, your point is that the inspector attached weight to the fact that it had been recently adopted,
yes,
but not to the fact that it was under review.
Well, that's right.
Okay.
That is right. Yes.
Yeah. All right.
So I've already taken the court to the paragraphs in the decision letter. I won't go there again. 13, 14, and 32, where the inspector places great emphasis on the recently adopted local plan, and I made my comments about whether that was a fair or accurate way of dealing with the development limits. My Lord, subject again to any guidance from the court, I'm going to leave that issue there, issue 3 of limits, and move to issue 4, significance of heritage assets. And can I just, particularly in the light of a perfectly fair point that my own friend Mr. Clay made yesterday by reference to our written case, my Lord, if the court would kindly get out our written case, which is in the core volume, starting at page 227.
Thank you.
And I'm concerned with paragraph 57, which is on page 247 of this core volume. And Mr. Clay understandably took the court yesterday to page 247, paragraph 57 of our written case, and the 3 points numbered 1, 2, and 3 on that page, and dealt with them. Lord, I want to say straight away that the second point, the inspector was wrong to conclude that the broad aim of AP4 was consistent with government policy in paragraph 135 of the MPPF, was a point that we trailed lightly in the courts below, and my Lord, I don't ask the court to be troubled by it. My case is in relation to 1 and 3, the significance of the heritage asset, aspect arising under the framework.
Right.
And my Lord, can I,
Thank you.
for these purposes, go to Appendix Part 2. Appendix Part 2, right at the end, page 614,
Yep.
to see how this arises. Page 614, you'll see, is the front cover of SPG 6, dealing with historic parks and gardens, published by the local authority in December 1995. On 615, there is a plan, and we've seen a much better coloured plan yesterday of the extent of the park, or at least the former park. And then at 616, we see the text. And, my Lord, if I go to the text, please. Here we see the attributes of the park as described in the guidance, and I won't read it, it's there for the court to read. Can I just highlight, if I may, about 8 lines from the bottom towards the right. I hope the court sees a sentence starting, Southern Park, now reverted to arable, although parkland trees remain, and so forth. Trees are in poor condition. Some trees are in poor condition. There was a curved drive, but the drive is no longer, etc. That, of course, is the part of the park which relates to the Hopkins site, and the conclusion of the assessment in the last sentence is all buildings are kept to a minimum boundary treatment, respect the open character park. The essential qualities of the park remain. Now, my Lord, that's a matter picked up in the decision letter. If I can go back to the decision letter in the core volume now.
Yes. Page?
Page 347, commencing
Thank
at 347.
Yes. Which page are we to look at in it?
And I'm looking at page 350, my Lord.
Thank you so much. Yep, thank you.
And you'll see the heading, the effects of the proposal on the local historic parkland and landscape.
Yes.
And you'll see in 15, my Lord, the reference to the document I've just taken you to. You'll see just over halfway down the conclusion, in quotes, the essential qualities of the park remain. And then the last sentence, the SPG notes that the boundaries of the parklands have been drawn taking account of that area currently forming the visible extent of parkland and any additional area which historically formed part of the extent of parkland and which continues to display remnants of that former park. Now, we don't actually have that reference in the papers in front of the court, but the earlier part of the SPG, when dealing with the boundaries of these parks, uses that concept as the driving concept, whether they display remnants of that former park. Then in 16, the inspector addresses precisely that point. And I won't read 16, but he makes judgments. About halfway down, he says the appeal site has now been separated from the larger area by a low post fence, etc. However, one of the key underlying qualities of parkland, that is openness and freedom from built development, remains. I also accept that planting exists, etc., etc., and concluding that these aspects, last line please, which qualify as remnants of that former park. Then, my Lord, 17 to 18 to 19 to 20 all deal with non-park or historic park matters. I accept, of course, in 21 that he says, in respect of these matters, the historic parkland forms a non-designated heritage asset. I conclude the proposal would have an unacceptable effect on the significance of the asset. Now, if one's asking where significance, as per the framework, is addressed, one can only find it in 15 and 16. And my Lord, I would just intervene here, please, to emphasise to the court that the paragraphs in the framework, 128 and following, were new in 2012 when they were introduced. They contain a carefully drawn set of policies to guide the public and decision makers through the otherwise complex business of the statutory duties relating to heritage assets and the non-statutory duties that apply in relation to non-designated heritage assets. And they are, as I say, carefully constructed by reference to the reference to significance which is in the glossary. And, my Lord, the submission here is, and always has been, that the inspector was addressing himself to a different point. He was addressing himself to whether, in terms of SPG 6, published some 17 years before the framework and the new policies, he was addressing himself to whether the land round about the appeal site displayed the qualities of the remnants of that former park. He was not addressing himself to significance of the heritage asset in the terms of the carefully constructed policies of the framework. And the simple reference in 21, we say, unacceptable effect on the significance, is not a sufficient response in substance to the policy matters that were in play and should have been dealt with. Lord, that submission...
I thought he was... I read it as being related to paragraph 215 of the framework. I mean, paragraph 215 says you can have regard to the policies of the local plan to the extent that they're consistent with the framework. The closer they are to the framework, the more you can apply them. And that's why he goes through the process of considering the degree of consistency between the policies in the local plan and the corresponding policies in the framework, and decides that they're close enough to be something which he should give some weight to, isn't that right?
But Lord, that's what's happening in paragraph 10. That is what's happening in paragraph 10, and that is the point on which I'm saying I'm not troubling the
But
court.
having done that, you can't complain about him applying the policy in the plan. You can't say that the framework supersedes the local plan.
Lord, I can't, but it's a material consideration to which regard must be had.
He's had regard to it. You say he hasn't had sufficient regard.
I'm saying he hasn't had any regard to how the framework constructs these policies in relation to non-designated heritage assets and the particular concept of significance, which is drawn carefully. My Lord may have some misgivings about the need to define these things yesterday, but the fact is, my Lord, that this is the most material consideration.
That was a flippant remark which I shouldn't have made.
But it is what we have. My Lord, those are my submissions. I've done better than I thought I would on the 4 issues, so far as Hopkins needs to address them. My Lord, there is an issue as to discretion. It hasn't been advanced orally by the appellants. It is tucked away right at the end of their case, and it is that the test in simplex, and perhaps the court just needs reminding.
Is there any doubt? Unless we're sure that the result would have been, if we think there's something wrong, then unless we're sure the result would have been the same,
that's the test.
Basically, you're entitled to have it redecided.
My Lord, that is the test, and my Lord, if I had to develop that, I'd take the court to the decision letter, from which we see that paragraph 14, although given lip service to in the earlier part of the policy, is simply ignored in the overall assessment.
Yeah, what is obviously an evaluation we can make in relation to the strength that we see in the points you've made.
My Lord, yes, but
the test is not in a issue.
Well, my Lord, I'm happy to leave it there, particularly with reference to paragraphs 13, 14 and 32, where it is clear that the inspector was decisively influenced by the assumptions he'd made about the relevant policies and their place within the framework, decisively influenced by other such matters, and the court couldn't possibly be satisfied that, absent the legal errors for which we contend, he would have reached the same result. Lord, I'm happy, unless the court needs any further assistance on that point, to leave it there.
And the effect of that would be what? That it would be have to be reconsidered by the same inspector? Or?
No, my lord, it would be reconsidered by another inspector, I think almost certainly. That is the normal, not the inevitable, that is the normal position, my lord. And the inquiries procedure rules deal with what happens should the orders below be upheld by this court, that there is a procedure for referral back, and I think in this case it's almost inevitable that a further inquiry would be held, and equally almost inevitable that it will be held in front of a different inspector who wasn't involved before.
And it will be considered in the light of things as they are now, not as they were.
It would have to be. It would have to be, because it would obviously be considered in the light of the guidance of this court, but also in the light of up-to-date policies at whatever level.
Seems to be a potentially endless activity.
But it's not unusual, is it, I'm afraid?
May not be unusual, but...
That's why you do
Should
planning,
I
isn't it?
complain?
But we can't grant you permission, even if...
Sadly not, my lord. There are many clients who don't understand that immediately, but that is the position. My lord, unless there are any matters that I can assist the court on further.
Thank you very much indeed. Thank you, Mr. Lockhart-Mumley. Mr. Simons. Mr. Young.
Yes.
My Lords, I appear on behalf of Richborough Estates, assisted by learned friend Mr. Corbett Bircher. I have a few preliminary points arising out of the submissions yesterday, and then the principal submissions will, I hope, take less than an hour, so less than the allotted time. But may I just indicate they're under 6 headings.
Yep.
The first 4 of which are concerned with the issue of the proper context, as used by the phrase used by the Supreme Court in Tesco and Dundee. And they are these. First of all, the MPPF, and just 3 quick comments about that. You've heard plenty about its contents already. Secondly, the Crewe and Nantwich replacement local plan, to just have a look at what the plan actually says. That's the adopted local plan. Thirdly, the issue of 5-year housing land supply. Fourthly, the specific policies that are the subject of consideration here, particularly NE2, NE4, and a passing comment or two on RES5, Residential 5. With all of that, and in line with the case, that's the proper context. The 5th topic then is the interpretation with that proper context and the way in which the Court of Appeal approached it, and then the alternative narrow and intermediate definitions that are offered by the appellants. And the 6th topic is discretion. As far as issue 2 is concerned, I rely on the written submissions, and they are short as they are anyway. And as to the issue of the Secretary of State's powers, I know that a great deal of effort has been made on the part of the advocates, both for Hopkins Homes and for Secretary of State. I don't think there's very much I can add to that. There are just perhaps 2 points if I have time, but I'll leave those till last and not waste the court's time with that. The preliminary points then, just very, very briefly, there are 6 of these. First of all, it has been suggested that the MPPF is inconsistent with the statutory scheme and development plans. In particular, in our respectful submission, that is plainly not the case. In fact, in my submission, it would go further than that. in our submission, the MPPF reinforces the primacy of the development plan, and we can find that in the MPPF itself. If I may invite you to turn up the appendices. The MPPF begins in Appendix Part 2 at page 206. The page I wish to take your lordships to is paragraph 14 on page 2. So Appendix Part 2, page 215.
Thank you.
Paragraph 14, and your lordships were told, and I don't think anybody here disagrees, that this is the linchpin of the MPPF. We are, of course, concerned here halfway down the box with the issue of decision-taking as opposed to plan-making. And the very first thing that's said is approving development proposals that accord with the development plan without delay. So the first thing it does, it tells everybody who wishes to read this document, including my clients and many other developers, that the most important thing if you want to get planning permission is make sure you accord with a development plan. So it's very difficult to say how this document undermines it when the clearest piece of guidance it gives, without any further tests, is to say, make sure your proposal is in line with the development plan, and there's an expediency about it, it'll be granted permission without delay. And I would suggest, with the greatest possible respect to my learned friend, that is supporting the statutory scheme and the development plan, not seeking to undermine it in any way. And as, if I may say so, my Lord Hodge observed, one mustn't forget footnote 10, a very important footnote in the context of the Edinburgh case and also paragraph 38.6. That is, in shorthand, the statutory test, unless material considerations indicate otherwise. So although there is a sophistication within that, contained within the further second bullet point of decision-taking in paragraph 14, we see the statutory emphasis on the plan and the statutory test emphasised there. The second preliminary point is that for all my learned friend Mr. Kingston's emphasis placed on the statutory scheme was not devised for the situation here. The statutory scheme assumes there's an up-to-date development plan. It assumes that. It assumes there's a continuity of provision in development plans. It wasn't written to deal with the situation here, and by here I mean obviously in Richborough's case, Crewe and Nantwich, local plan, where there's no up-to-date plan, and there's no planning for the development needs of the area. The parliamentary draftsmen were not envisaging the breakdown as occurred in the development plan system which took place at the turn of this decade in England.
I'd be surprised if they weren't aware that plans are not always up to date.
Well, I
which
wonder
has been
when
a feature of, I suspect,
yes.
planning since any of us can remember.
Well, I think, if I may say so, that's a fair observation about the time it takes, the delay, and usually plans, as soon as a plan is adopted, the local development forward planning team don't sort of turn off their phones and say, well, we'll come back in 15 years. They're continuing to work on the plans. I think what was novel at the turn of this decade was that we were getting to a stage where there was no development plan continuity. So the Crewe and Nantwich plan finished in 2011 as far as planning for development needs are concerned. Mr. Boylan, the inspector, was sat in an inquiry in June 2014, and the plan had finished 3 years ago. I don't think, although there's delays in the system, I don't think that situation was envisaged by the statutory draftsman, with my respect for
Well, I mean, it doesn't really matter because...
and no doubt, in my submission, that delay, particularly evident around 2010 to 2012, is in part the thinking about the content of the MPPF, and the government trying to come up with a practical solution, which in my submission was seeking to save the development plan system, not get rid of it. They contemplated that, clearly we saw from the submissions yesterday. But they were looking to save it, but find a way of dealing with all of these plans that had effectively run out of time and were no longer catering for the development needs of the time. Thirdly, the council itself, at the planning appeal inquiry, so this is my third point, preliminary point, is, and at the inquiry and in the High Court, accepted that policies for the supply of housing included policies protecting open countryside. That was their case at the inquiry. That was their case in the High Court. And more specifically, it was policy NE2, which carries the title Open Countryside. We'll come to it a little later on in submissions rather than take it up now. And it was that policy that the appellants were saying was a policy for the supply of housing, but not from the housing chapter of the plan, from the countryside, or the chapter dealing with countryside and dealing with the natural environment. So they were already willing and perfectly able to accept, as they did, in court and at the inquiry, that that was the position. That's recorded for your Lordship's notes at paragraph 31 of the inspector's decision. That's Appendix 1, page 54. Fourth point, my Lord Neuberger said you were troubled, my Lord, yesterday by the fact that one has a statutory development plan and then the Secretary of State can put a gloss on that, and that obviously is causing the court some concern as to whether that's undermining the statutory provisions in light of the way in which the power is arrived at. But in my submission, all that paragraph 49 does is to permit the decision maker to judge the policy as not up to date. That's all it says. It doesn't say abandon the plan. It doesn't say abandon the policy. And it does not determine the outcome of the application of the appeal. We see that in Lord Justice Lindblom's judgment at paragraph 47. He goes out of his way in lines, if I can take this quickly, in lines 10 to 17 of paragraph 47, he goes out of his way to say, well, the policy may be a policy that is judged not up to date, but it could still be the basis for refusing permission, because, of course, what the MPPF can't do is prescribe the weight. It can't say...
I don't understand that with respect, because the whole point of paragraph 14 is to talk about what happens when your policies are absent or silent or out of date. So your out-of-date policy is equated to something that was silent. It doesn't say, oh, well, we then give it whatever weight we like. It's exactly the reverse. The whole point is to displace the out-of-date policy.
May I make two submissions?
I mean, it doesn't, of course, it's not your problem, because all the policies are out of date in your case. So in
Yes.
a sense, like Mr. Lockhart-Mummery in a different way, you don't have to argue the generality.
No. May I make two submissions in reply to that, my Lord, which I hope are helpful? The first is, the phrase in paragraph 49 isn't actually out of date. It is not up to date. Now, the Court of Appeal asked that question directly. Do they mean opposite things? But simply to say that a policy is not up to date when the plan ran out of steam in 2011 is in many ways just a statement of common sense.
I know, in your case, it's a statement of the obvious.
Yeah, but the second point is, in relation to that, is that where the courts have gone wrong, and in the High Court in this case, where the court went clearly wrong, was to somehow imagine, whether you use the phrase up to date or out of date, that it was to then be disregarded. So in the High Court, Mrs. Justice Lang came to the conclusion that one would disapply the policy. And we find that in the judgment. May I just take you...
I mean, I know that's what she said. Yeah. I just don't see how you reconcile it with the words of paragraph 14. I mean, it seems to me in the light of paragraph 14, it's understandable that she said what she did.
Yeah. Paragraph 49, the policy we're concerned with, is a policy indicating that the policy is just not up to date.
Yeah, I know, but when you go to... Everyone, as far as I understood, accepts that then takes you to paragraph 14, which tells you what you do about it, at which point you treat it as though the policy was silent or absent.
Are you saying there's a difference between not up to date in 49 and out of date in the fourth bullet point in 14?
May I say two things?
Yes,
potentially, yes, which is the submission I gave in the Court of Appeal when asked that question by Lord Justice Lindblom. More importantly, it's not It's not disregard the policy, have no regard to the policy, undermine the statutory provisions. All it's saying is this policy isn't up to date. And why isn't it up to date? Because there isn't a 5-year supply of housing in the district. Why is there not a 5-year supply in the district? Well, there's not a 5-year supply because there must be policies which are pushing in the direction of not providing enough housing. So, for example, on a practical level, around the city of Birmingham is a green belt.
Yes, yes.
That green belt is a policy which obviously restricts the housing. The City Council adopted last month a plan which removes 5,000 houses from the green belt, much to the pleasure of Mr. Kingston's clients. Before the plan was adopted, relying on the previous policies of where the green belt boundary, on the council's approach, the appellant's approach, that policy is up to date. It's fine. There's nothing wrong. You can give it full weight. But everybody knew full well that the Birmingham plan, the old Birmingham plan, wasn't dealing with development needs up to that point in time. The Birmingham development plan was absent a necessary series of allocations to try and achieve its objectively assessed need. So the existing Greenbelt plan in the previous Birmingham plan was not up to date. It wasn't dealing with housing needs.
So, I mean, is what you're saying that all it means is that you treat the policies out of date to the extent that they restrict the supply of housing to less than 5 years. But subject to that, you give them such weight as they deserve as policy. So you give full weight to Greenbelt policy, less weight to a village boundary.
My Lord, exactly, if I may say so, exactly right, because in the first 5 lines of Lord Justice Lindblom's decision, he makes absolutely clear that the issue about the weight to give the policy, which is for decision maker, would depend on the size of the shortfall.
I understand that, but one of the problems, it could be said, is this. If you look at the 4th bullet point in paragraph 14 on page 215, it seems to treat out-of-date development plan in the same way as absent from the development plan. Where the development plan is absent, silent, or relevant policies are out of date, the same conclusion applies.
Well, in my submission, there are 3 different routes. This is often debated at public inquiries. These words have been subject to...
It's now being debated here.
Subject to Mr. Justice Lindblom's decision in Blore Holmes and the Secretary of State in Hinckley and Bosworth as a High Court decision, as he then was. Mm-hmm. The absent and silent is extremely unusual because it would be very rare not to have a plan at all. The more likely route, the more commonly used route, is relevant policies are out of date.
I understand that, but this is dealing with general sustainable development of any sort, isn't it? Not just housing.
Yes, yes.
So the fact that it may not deal with housing doesn't really matter. This is a general proposition in 14.
Yes, it does, and the route that is... so it doesn't need to be housing. This could be a proposal for...
well, quite, but all I'm putting to you is that it seems to treat silent, absent and out of date as the same thing. The same conclusion applies.
Well, they're different routes.
Yes, they're different routes to the same result.
Arriving at out of date, yes. Whether the plan was completely absent, imagine a plan that had nothing to say of any substance, one would presumably give those policies less weight, although if they're silent and absent, they wouldn't be there.
Right.
Relevant policies to the application are out of date because they are not dealing with the development needs of the area. And in the housing context, the weight you give it, as Lord Justice Lindblom indicated, is determined by a range of factors. Just because the policy back to 49 is not up to date, one doesn't, as Mrs. Justice Lang did, disregard it, paragraph 61 of her judgment. What one does is then make a judgment, and that judgment is best made by the decision maker. They are in a position where they are facing a plan, in the Crewe and Nantwich case, which is out of date. There isn't a 5-year land supply. We're in a position that might be said to be a complete stymie, as my Lord Gill indicated yesterday. What is the solution? What does the decision maker do? The decision maker has been told that the development plan remains in place. The development plan is the statutory plan. But we know the plan stopped planning for development needs in 2011. So how do you overcome this?
But the specific policies in the framework don't come back in, do they? The second dash under the last bullet point.
The specific policy, those are further protection which would disengage the presumption
Quite.
in circumstances where it's a greenbelt. So for
That of itself doesn't take you back to the plan, to the development plan, does it? It does take you back, or does it?
Well, it does take you back to
Twice.
the development plan. That seems to me to be
Exactly.
the point, that the circumstance where the development plan is absent are different from when it's out
Right.
of date, because the second dash in the second bullet point refers you to the footnote 9.
Exactly.
And in footnote 9, when you're seeing what is the land designated as green belt or local green space or heritage site, etc., you go back to the plan.
Yes.
And so what the framework is saying is we create a presumption in favour of the development, but if there are specific policies in the plan which are consistent with this framework, which are restrictive of development, you have to give them weight and they may overturn that presumption.
Absolutely, and one would be in a position where one would find a lack of fibre land supply, a development plan policies are not up to date, so one is thinking about reducing the weight because of the factors that Lord Justice Lindblom identified, size of the shortfall, the extent to which the authority is doing something about it, bringing forward a new plan and so on. One then travels to paragraph 14, as your lordships quite rightly remind me, one looks at the application of that. But if the site is what we often call a footnote 9 site, then one doesn't apply the presumption that is said to tilt the balance.
But you accept that the footnote 9 sites, I mean, although it refers to specific policies in the framework, it also includes footnote 9 sites designated in the local plan. So, I mean, for example, it must be so in case of local green spaces. I mean, you've got to look to the local plan to see what they are. So that
Yes.
those sort of policies, specific policies, come, whether in the development plan or the framework, come back in to displace the presumption, or may do, depending on their weight.
My lord, exactly right. And for all my learned friend's emphasis yesterday, with great respect to him, about the green belt and somehow the interpretation that the Court of Appeal has given on paragraph 49 as sweeping away the green belt, it does no such thing. Paragraph 49 does take you to paragraph 14, but one looks then, in terms of the tilted balance, one looks at the footnote 9, the last dagger point in the last part of paragraph 14, and one sees instantly that the presumption or the special emphasis or tilted balance, however it's called, doesn't apply. Now, what's remarkable in this case is that footnote 9 is a non-exhaustive list, and it includes greenbelt and various other environmental policies, area of outstanding natural beauty. None of these are subject to the presumption. As a non-exhaustive list, the council could have argued at the inquiry that the green gap was a footnote 9 policy concerned with environmental protection.
But can I just stop you here? If this is right, can it be said that the reference to out of date doesn't have any meaning? Because while all the policies that would prevent development are taken out because of the bullet point, if you're right, are they not all brought back in under the dash?
Yes, I mean, as a matter of fact...
Which is a very peculiar result. Or is it more nuanced than that the policies apply as a result of the dash, as it were, with rather less force?
In my submission, well, it's ultimately for the decision maker what weight they give it.
Well, no, but the question of what this means is not for the decision maker.
Well, may I offer this then? In terms of the way it works in practice, is that one can go down the paragraph 14 route, but one is not allowed to then apply the test, which is the tilted balance. So you cannot go into your inquiry or your planning application and say these policies are out of date, which is a decision that is made. Somebody has to make that decision, whether it's the local planning authority, whether it's the inspector, granting permission unless, and then the tilted balance. Any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies of the whole. You're not allowed to apply that extra tilted balance if you're in a footnote 9 situation. So you don't get...
Sure, it's much simpler than that.
It is simpler.
Well,
Don't go.
no, I mean, it seemed to me that what's out of date is the policies, the housing policies, which fail to meet the objectives set out in paragraph 47. They don't provide a 5-year supply. They don't. So that takes you into this 14,
Yes.
and it says, well, given that situation, there's a presumption for granting permission unless there's adverse impacts which outweigh the benefit, bullet 1, or specific policies, footnote 9 policies, which displace the presumption.
Yes.
And I mean, what's wrong with that?
Yes, can I first of all agree entirely, and secondly, if I haven't explained myself clearly, but that was the point, that you don't apply the tilted balance. So the first...
What do you mean by the tilted balance? Define for me the tilted balance. That seems to be introducing a complexity that doesn't need to be there.
It's the phrase that everybody uses, or the Secretary of State...
Never mind who uses it, what's it mean?
Okay. The tilted balance is the first dagger point in paragraph 14. So we've got 2 bullet points, and then we've got what people call the dagger points, or just the further indent.
I see.
That is the tilted balance test, and it applies in every application and every planning appeal up and down the country. And you're right, my Lord Hodge, if I may say so, it is just a phrase that isn't there in the language of the MPPF in paragraph 14.
It's a shorthand for the first
exactly
bullet point.
It is exactly that.
Yes, you're saying that it's simply grant planning permission unless first dagger point. That's the tilted balance. But
if you're in the green belt, you can't.
I see.
Yeah.
I think it's rather sort of poetic term. But
Yeah.
Well, everybody except us seems to use it.
better get into it.
My lords, I am still on my preliminary points, I'm afraid. But I fear I have to answer the questions as they come. I hope that's not impertinent to say that. The fifth point is that the appellant's interpretation, the narrow interpretation, finds only policies in the housing chapter of the plan to be not up to date. So if there's a finding that the council can't demonstrate a 5-year supply of housing land, the only policies that are then judged not up to date are the housing policies themselves. And that achieves precisely nothing, because the policies include, for example, I won't take you to them, but Residential 1, which is the policies for housing allocations, Residential 2, which permits development on unallocated sites, and it even extends to Residential 12 and a policy entitled Living Over the Shop. These are all policies to do with housing in one form or another. The policy Living Over the Shop is to encourage that. Now, the consequence of the appellant's interpretation is simply to find those policies are out of date. But that won't deliver a single... It's peculiar that those that facilitate the delivery of housing would actually be then judged the ones that are out of date. And secondly, it wouldn't deliver a single further house. If you've got an allocation policy, it's allocating houses. It's a policy that you would wish to be there to ensure the delivery of housing, not a policy you'd wish to see diminished in weight. But the only way that there'll be any more houses in Crewe is if the view is taken that paragraph 49, second sentence, applies to countryside policies which restrict the delivery of housing, and indeed the Green Gap, which, for all the reasons that Mr. Boyland, a very experienced inspector of 25 years, identified, he could see that the Green Gap had effectively the same purpose as the countryside policy. Here is Crewe, the main town in the borough, identified for growth, wrapped in a policy which has a settlement boundary and a green gap in addition to the south, the west, and the east of the town, in a policy that ran out of steam in 2011, you won't be able to deliver a single additional house unless you find those policies are out of date. And that was the point that Mr. Justice Ousley made in the High Court in the Barwood case. He described them as the counterpart policies, counterpart to the housing policies, a phrase adopted by Lord Justice Sullivan and approved by him in the court below. So this fifth preliminary point is that the council's interpretation achieves precisely nothing, absolutely
What
nothing.
do you mean by Lord Justice Lindbrom?
Sorry?
Lord Justice Lindblom.
Lindblom, sorry, did I?
Yeah, you said Sullivan, yeah.
I'm sorry, Lord Justice Lindblom, yes. And the final point is to say that to listen, sixth point, to listen to my learned friend Mr. Kingston's eloquent submissions yesterday, one would be forgiven for thinking that where there is no 5-year land supply, every applicant who comes to a local authority with a housing application is granted planning permission. And if somehow that doesn't happen, every appeal is granted because the policies fall away, the development plan has no status. It simply doesn't work like that. Plenty of appellants, plenty of people listening in this room will have experienced a situation, as my learned friend Mr. Lockhart-Mummery said yesterday, of a council not having a 5-year land supply, but they will nevertheless lose their appeal because the inspectors recognise that a policy should continue to be given weight. One example that befell clients of mine last year, Waverley Council, where Farnham is located, a site in Farnham, the main town. It was only for 30 houses, no 5-year land supply, but they didn't win the appeal. The inspector recognised it was in flood zone 2, and flood zone 2, under the sequential test, is not a location where one would ideally put houses, although one ultimately could, and as a consequence of which, the appeal was dismissed, regardless of the 5-year land supply position, because it just wasn't the right location for housing. So in my submission, what we have here is a slight over-exaggeration about the consequences of it. It is left to the judgment of inspectors, as indeed Mr. Boyland, who identified very clearly that NE2 and NE4 were having an effect of constraining the supply of housing. My Lords, can I just then turn to my points, and I'll try to take these very quickly if I can, to try and keep within the time estimate. The first point, can I just make a minor correction to our case? So our case is in the core bundle. It's just to correct a footnote reference, but at page MS 216, footnotes 35 and 36 begin with MPPF. That's a mistake, I'm afraid, on my part. It should say the appellant's case. So that's the appellant's case rather than the MPPF.
That's page?
Page MS 216.
Thank you.
Footnotes 35 and 36 should both read not MPPF, but appellant's case.
Thank you.
Topic 1 then, the MPPF, and as I say, your Lordships have heard plenty of its contents and read plenty of its contents.
Yep.
Everybody agrees that it is part of the proper context. I make 3 very, very brief points, if I may. 1, sustainable development is seen to have 3 dimensions: the economic, the social, and the environmental. And you have that at paragraph 6 of the MPPF. So it isn't just about environmental policies protecting the environment that local people, Mr. Kingston talked about local people wishing to protect their environment and signing up to the plan. There is also this need to deliver the houses which many people find difficult to accept in their local area, the NIMBY acronym often used. There is a need to balance the social, which is the housing dimension, with the environmental and the economic, and that is why each is recognised in the MPPF. The second point is what that means in reality is that no matter how much local residents wish to protect and enhance their own environment, there is this requirement in paragraph 6 that the supply of housing required to meet the needs of present and future generations is met. And that also is paragraph 6. And the third point, and perhaps the most important point about the MPPF, is that in numerous places the MPPF makes clear to local planning authorities they must have up-to-date plans. This is repeatedly made, particularly at paragraph 17, plans should be kept up to date. Paragraph 12, it's highly desirable that local planning authorities should have up-to-date plans in place. The government could not have been clearer in telling local authorities, such as Crewe, if you want all the protection and the benefits that come through a development plan process, first of all, you've got to have one. You've got to have one that covers the present period. Why did it say it's highly desirable that local authorities should have an up-to-date plan? We find the answer in my submission in the context of this case by looking at the development plan. Topic 2 then, the Crewe and Nantwich replacement plan. The 3 contentious policies are NE2, NE4 and RES5. We looked at those yesterday. I don't ask you to take them out now. The appellant has put the full plan before the court. It chose to do that in Authorities Bundle 4B. I've got no complaint to make about that. Might I invite the court, please, to turn to Bundle 4B, tab 50.
Yep.
And MS2254, MS2254.
Yes.
This tells us some key facts right from the outset, that the statutory basis for the plan, so the legislative provisions with which your lordships are concerned, at paragraph 1.1, the replacement local plan has been prepared, 2254.
Yep.
It's at the start of 4B, if I At 1.1, the replacement local plan has been prepared by Crewe and Nantwich Borough Council in accordance with the 1990 Act. The plan covers the whole of the borough of Crewe and Nantwich. It amalgamated into 3 that's set out in the skeleton items and relates to development up to the year 2011. So for all my learned friends' repeated suggestions that local people would consider it, and I quote, a disaster if there was to be development in the Green Gap, local people properly informed knew that their development plan only covered the period to 2011. That was the period by which the protection was there and the policy was current and the development needs had been satisfied through the allocations up to that point. At 1.3, it says the Borough of Crewe and Nantwich local plan was first produced to deal with the period up to 2011. So the actual plan that your lordships are concerned with is called the replacement local plan. It replaced the original one. This was adopted in November 1997. That's the original one, after passing through a number of statutory stages, culminating in a public local inquiry in 1996. This document is a review of the local plan. It was prepared within the framework of the Cheshire 2011 replacement structure plan, which was adopted in 1999. You'll notice they always use the end date by which to suggest the date of the plan, but the Cheshire plan, with which it needed to be in general conformity to meet the statutory provisions relating to structure plans and local plans at the time, was a plan itself, the structure plan, that was only planning to 2011. Like the structure plan, it deals with the period up to 2011. The point being that everybody was aware that as far as the protection associated with sites which were not in the plan and were coming forward, it was only to 2011, because that was all it was suggested. Mr. Boylan, the inspector, sitting there in June 2014, knew that. He knew the plan was only intended to last that. What needs was this plan meeting? May I take your lordships, please, to MS 2260, page 7 in the document.
What page?
2260.
2260, thank you. Yes.
Halfway down the page, to meet housing requirements by, and then these were the objectives of the plan, allocating sufficient good quality housing sites primarily in and on the edge of Crewe and Nantwich as required in the Cheshire 2011 replacement plan.
Yep.
And the target was 7,600, which we see in the bullet point below. So that was the context of the plan. It was a plan that had no real currency and no real value in 2014, because the one thing a development plan is meant to do is plan for development. But here was a plan which the council were relying upon in 2014 to say my clients were not entitled to have planning permission on this site, based on a plan that was only intended to deal with needs up to 2011. And not unsurprisingly, in my submission, absent an up-to-date local plan making appropriate allocations, there was a failure to meet the housing needs. And a failure to meet the housing needs meant, unsurprisingly, there was a lack of 5-year land supply. And if there's no plan in place addressing present and future needs, one can hardly expect there to be a healthy supply of housing in the borough to build houses because there's no planning for it. All that's happening is the local authority are relying on their old plan, which has run out of steam, to say, well, all the environmental protection that laps at the edge of Crewe with its settlement boundaries and its green gap, all of that remains current. In other words, the complete stymie. You can't deliver the houses because of the plan, but the plan isn't dealing with the needs. This is the situation the MPPF was dealing with, not the situation that Malone and Friend would suggest, that everything was fine. There was a development plan, everybody had signed up to it, everybody knew what was happening. It was unfortunate that there was development in the green gap. The implausibility of the council's position was even more stark when it emerged during the preparation of evidence to the inquiry. The council itself was granting planning permission for sites in the green gap. So my client's site had been refused because it was in the green gap. The year before, in 2013, the council itself was granting planning permission for housing sites on greenfield sites in the green gap. This was evidenced by the proof of evidence of Mr. Sitch, who was the planning witness for Richborough Estates at the planning inquiry. Might I take your lordships, please, to Appendix 2, where he sets this out. Appendix 2, MS 558 or page 303 in the hard copy. 303 in the hard copy, MS 558. 303. 303. That's hopefully just the first page of the proof of evidence at 303. Do your lordships have that?
303.
303. Sorry.
Okay.
Is your planning?
Yes, proof of evidence of Mr. Sitch, yep.
My lord, I'm sorry, I didn't catch that.
Proof of evidence of Mr. Sitch.
Yes.
Yes, thank you.
Okay, and if we go then, please, to page 322 within that, and that's MS 578. What Mr. Sitch evidences at paragraph 411, extant planning permissions, in the context of having refused my client, the council has granted permission for development at Williston, that's the settlement we were next to. There have been 3 recent grants of planning permission. These include, firstly, land at Shearbrook Road, Williston, 21 dwellings. This was approved in November 2013, so about 7 months before the inquiry. Following confirmation from the council they did not have a 5-year land supply, development has not yet commenced on site. A copy of the officer's report is provided at paragraph 23. A summary of that report is provided in the rest of this paragraph. The site is located in the open countryside, NE2, and Green Gap, NE4, and was approved on the basis that the council were unable to demonstrate a 5-year supply. In light of recent appeal decisions, the automatic presumption in favour of the proposal applied, and NE2 and NE4 were considered out of date. The council themselves, in the year before my client's appeal, considered their own policies.
These are sort of jury points, aren't they? I mean, you're not here to re-argue your planning case that you won.
No, but my lord, I suppose the only point goes to credibility. It's being said that these could not be relevant policies for the supply of housing. But here was the council the year before granting planning permission on that basis.
Well, whatever they were not sufficiently strong to prevent the grant of permission. And you would say in your case the inspector looked at that and decided it wasn't critical for the green gap.
Because of a lack of 5-year land supply, the council judged the policies, those policies, NE2 and NE4, were out of date.
How does the consistency of the council's approach help us interpret the policy?
Well, my lord, I move on from the point simply to highlight that what is suggested now could not be contemplated.
I'll never underestimate the value of the merits, I suppose.
Or jury points, even if it's...
Well, 5, not 11.
My lord, I've highlighted that point. I'll move swiftly on.
That would 12 would be a disaster.
The position in terms of the appellant's closing submissions at Appendix 2, page 272, page 272.
Yeah.
The point that the appellants were making in closing submissions was that at bullet point 1, there was no regional strategy, there was no structure plan, and the council had not produced a local plan for nearly a decade.
I mean, all this is just, I mean, the strength of your case is that this plan was clearly out of date. You don't need paragraph 49 to tell you that. And so you get back to paragraph 14 and you say there's the tilted balances in your favour, and and the inspector found there were no specific footnote 9 policies to stop you. End of case.
My Lord, on the point of discretion, which is my last point, yes, I completely agree. Wouldn't have made any difference.
That's effectively what the inspector had to go through the motions of all this thing of deciding what was a housing policy and what wasn't. But actually, in substance, he comes down to a good old traditional approach.
And my learned friend, Mr. Kingston, accepted yesterday, in answer to questions from your Lordship and Lord Gill, the position as regards whether the outcome would be any different. Whichever route he took, the outcome would be the same. And that obviously, in respect of the Richborough case, goes to the issue of discretion. But may I just make one point, though, without turning it up again, which was that the development plan was, I think, not unfairly described as emasculated because it wasn't dealing with present development needs. Your Lordships had provided this morning a copy of the saving letter, which dealt with the status, the Secretary of State.
Where is the provision which deals with saving?
Schedule 8.
Schedule 8.
Schedule 8.
Well, we have copies if the court wants to see that.
Not very much. I see.
Paragraph, sorry.
My Lords, could I take you to the third page of this? So the saving letter, as it's called.
This is what? Is this the 14th of February 2008 document?
Yes, my Lord, yes. And there's a direction on the third page, and Lord Hodge, to your question about which provision it's set out there.
Paragraph 13. Okay.
And it sets out the policies that were saved. There's no dispute that these policies were saved. But may I just direct your attention just very briefly to what's said in the letter from the Secretary of State. He attaches his saving direction in the second paragraph, and then in the fourth paragraph, the Secretary of State's assessment of whether save policies should be extended is based upon the criteria set out in Planning Policy Statement 12, which was current at the time, and the Department of Community and Local Government's protocol on saving policies. The extension of save policies listed in the direction does not indicate that the Secretary of State would endorse these policies it presented to her as new policy. It's intended to ensure continuity in a plan-led system and a stable planning framework locally, and particularly a continual supply of land for development. Local planning authorities should not suppose a regulatory style plan would be supported. And then the final paragraph on the page, the exercise of extending save policies is not an opportunity to delay DPD preparation. LPA should make good progress with local development frameworks according to the timetables in their local development schemes. Policies have been extended, in the expectation they'll be replaced promptly by fewer policies in DPDs. Maximum use should be used of national and regional guidance. That letter was dated the 14th of February 2018, addressed to the planning manager at Crewe and Nantwich. We are nearly a decade on, and they still don't have an adopted development plan covering the current period. 9 years later, and they still don't have a plan. And to my Lord Carnworth's point, yes, the plan is out of date, but it wasn't as if the council weren't given fair warning by the Secretary of State to have policies in place. Otherwise, national policy will be applied, and national policy obviously now includes the MPPF and the presumption in favour of sustainable development. The plan was absolutely, by 2014, redundant in terms of addressing development needs. My Lord, this situation that Crewe finds itself in is perhaps unusual, or Cheshire East, I should say, finds itself in is perhaps a little unusual now in 2017. There's a significantly lower number of, or less number of local authorities that don't have an up-to-date plan. But at the time the MPPF was drafted, the situation was very different. Might I just direct your attention to a second letter that is on hopefully your desk, which is a letter from the DCLG to Simon Ridley, the Chief Executive of the Planning Inspectorate. Unfortunately, this letter doesn't carry a date, but we've managed to attach the website entry, which shows that it was a letter of the 21st of July 2015, and that's behind the letter itself. What the letter indicates is it's reflecting back on the progress that's been made with development plans over the currency largely of the MPPF. And in the second paragraph it says, if I may, we have recently seen significant positive plan-making progress. 82% of authorities have now published local plans and 64 adopted plans, compared to 32% and 17% in May 2010. So in May 2010, before the MPPF came in, only 17% of local authorities had an adopted plan, subject obviously to the saving. There was a large-scale breakdown, for a variety of reasons that I don't need to trouble the court, in having development plans. This letter refers to statistics from 2010. In 2011, the government went out to consultation on the MPPF, which was adopted in March 2012. So this was the situation, the breakdown in plan making that existed at the time that the MPPF was brought into force. And it would be difficult not to imagine that that type of statistic, startling statistic about the lack of local plans, was not a feature in the thinking of the government's solution in saving the development plan process, but looking for a solution to allow decision makers to allow housing and other forms of development forward if there wasn't an up-to-date plan. The MPPF at paragraph...
Again, I'm not sure this matters really, but it was really one of the problems for local authorities was that the format of plans changed on several occasions, and so the plans that they were working on under the old system then had to be updated under the new system. But it doesn't really make any difference to your case.
Well, my lord, I think if I may say so, it's a very valid point. It's made in our case to the court specifically that it doesn't really matter, to apportion blame as to why there was this breakdown in plan making and why the MPPF was required. Yes, local authorities said you introduced a new system of core strategies and allocation DPDs, and we're unfamiliar with it. Other people would say there was a reluctance to get on with it and a reluctance to allocate sites because it's locally controversial and it's sometimes easier to duck away from that issue and allow the inspectorate to bring the sites forward for appeals. But it doesn't really matter ultimately. The position was there was a complete breakdown in plan making in this country prior to the MPPF, and therefore the MPPF is, as my initial preliminary point, reasserts the primacy of the development plan but looks for a solution that the statute didn't envisage, where there are effectively plans that are largely absent of content to help deliver housing. There is, if I can just make this additional submission, there is no statutory mechanism to adopt the plan. That is set out in paragraph 25 of our case. I don't turn that up. In fact, it's the exact opposite. There is a statutory power given to all local authorities which permit them not to have to adopt a plan. So at any time before a plan is adopted, it can be withdrawn, and that's section 22 of the 2004 Act, the Planning and Compulsory Purchase Act 2004. I don't think that's before the court, but there it is, a power to say, well, you can take it all the way through. If you don't like the inspector's report, ultimately you don't have to adopt it. You can abandon the plan. It is in tab 1, MS 902, but to save time, if I just give the reference, tab 1, MS 904, Authorities 1. And you'll see, my lords, also at section 23 of the same Act, and that's MS 903 again, that local authorities may adopt a plan, either as originally prepared or modified, but they don't have to. There's no shall. It is voluntary as to whether they adopt a plan. And if the inspector's report comes back saying you need to provide more houses and they don't like it, section 22 gives them the ability to abandon the plan and no planning for that future period. My Lords, the third topic is five-year land supply. And to the point that is made against us, or may be made against us in reply, well, and I think if I may say so, it is a point that my Lord Carnwath has repeatedly made to the submissions here, is that, well, that's all very well for Cheshire East. There's clearly an out-of-date plan. The inspector may well have come to the same conclusion. But what is the purpose of paragraph 49, for example, in the Suffolk coastal case, where they have an up-to-date plan? In my submission, one needs paragraph 49 as well as paragraph 14 for three main reasons. Some of these plans are so late, they're being adopted, but they're so late in being adopted that to ensure a continuous supply of housing, the plan is not the solution if adopted as Cheshire East hope later this year. That's not going to solve the problem. The reason is, and my Lord Gill and Lord Carnwath may be very familiar with this, most development plans have a series of large sites, sometimes called sustainable urban extensions. The plan-led system tries to introduce these more comprehensive, more sophisticated developments. These large sites won't start delivering houses on the day the plan's adopted. Typically, developers will wait. Sometimes they'll wait until the plan's adopted, although they may put their applications in beforehand. Such applications can take a long time to prepare. There are countless reports produced, landscape reports, ecology reports, and so on. The application is subject, particularly if it's a large application, which many of these local plan allocations are, subject to discussion and negotiation with the local planning authority. The large sites are often secured in outline first, so there's 3 years usually or longer given to submit the reserved matters, which is the architectural detail and the detail of the individual houses, their siting and layout. So in truth, especially for these large sites, it can take years for them to be delivered. And in the meantime, so the plan is adopted, the large allocations are 5 or 10 years away from actually delivering any completions that might affect the supply of housing. And in the meantime, there are no completions. So paragraph 49 has the effect, which the court has observed does appear to be strange, which is that you have a recently adopted plan, but that plan can be found to have policies that are not up to date because there's a lack of five-year land supply. Well, that's because the plan was adopted very, very late. Crewe and Nantwich should have adopted their plan well before March 2011. There should be continuity of plan coverage. But the reality here is that they haven't. They've actually ended up with a gap. And if they are fortunate enough to adopt it in 2017, we've had a 6-year gap. So if it is adopted this year, that doesn't necessarily overcome the problems of housing delivery. And the plan is not always the solution to housing delivery. As Winston Churchill said, however beautiful the strategy, you should occasionally look at the results. You may have a brand new development plan that seems all shiny and new and very impressive, but if it's been late in its adoption by 6 years, 7 years, it's not going to achieve the results of delivering houses. Crewe and Nantwich were told in 2006, the saving letter, 2008, get on with your plan then. And paragraph 49 is the solution in my submission. No matter how beautiful the Cheshire East plan is, and I'm sure it is making strident efforts to deliver the 36,000 houses that it now proposes, once it's adopted, one occasionally does need to still see whether there's actually a 5-year supply of housing. And in the case of Suffolk Coastal, if I may be permitted just one observation, the plan on its very face accepts that it doesn't deal with the housing needs. So as my Lord Carnwath observed, one can see how it might be said that you've got policies that are not up to date in terms of addressing housing needs, which paragraph 47 of the MPPF requires, but subject to other planning limitations. Far from the MPPF undermining or superseding, as the appellants put it, far from it undermining and superseding the development plan, it is in fact shoring up the development plan process by keeping the development plan there as the basis for decision making, but saying to the decision maker, look, this plan finished before, and if it's finished before, then you can have the confidence to reduce the weight for the policies for the supply of housing. And in my submission, what it achieves is a signpost, really, as to giving the decision maker that confidence. Topic 4 is NE2 and NE4.
Just before you go on to that, please, Mr. Young, in England and Wales, does an adopted plan have to be submitted to the Secretary of State for approval before it acquires legal force?
It needs to be, there's a supervisory role for the Secretary of State.
So it's submitted for examination,
Yes,
and the Secretary of State doesn't have to approve it, but he can intervene and direct modification.
yes, you're absolutely right, my lord. And he appoints the inspector who will overlook the plan.
Yes. Is that in Scotland? Does he have to approve?
No, it has to be approved in
It has to be
Scotland.
actually approved. Yeah.
So what happens if the Secretary of State's given an adopted plan that freely acknowledges that it doesn't meet the housing need? Then what?
Well, the mechanism that my learned friend, I think, is going to, Mr. Kingsley, refer to in reply, arising out of the decorum case, is that one can have a review mechanism and say, well, this plan doesn't do all the heavy lifting it needs to do. It takes 3/4 of the need, deals with that. That should be seen as positive. The argument is it's often better to have a plan than not have a plan. And in circumstances such as that, there then is a commitment to review, often within about 3 years, to then have a plan that does cover the whole of the plan period and provides the necessary provision of housing. And that I think...
He can, in theory, he could direct modifications, but that would entail him sort of getting down and rolling up his sleeves and trying to find some housing sites. So in practice, what he does is to tell them to modify, to review it.
My lord, entirely correct. It's very difficult to sort of tell the authority there and then with the Secretary of State breathing over their shoulder, go and find these sites. But if they're given 3 years to do it, that is sometimes seen as a way of encouraging them rather than forcing them to find the additional sites that they may need. My lord, may I go to the 4th topic just before turning to interpretation? NE2 and NE4, there is in our submission a very clear link between the supply of housing and the policies that constrain it. The court below recognised this relationship very clearly, and this is the phrase about counterpart policies. But it's also evident from other evidence that's before the court in my submission. The 2003 Local Plan Inspectors Report, which your lordships were taken to yesterday, that is in Appendix Bundle 2, page 507, or MS 762. So this is just to orientate, this is the 2013 Local Plan Inspectors Report. It carries, as your lordships observed yesterday, the end date of the plan, 2011. May I direct your attention just to paragraph 14.2.5. And here the local plan inspector is dealing with a green gap policy, which he's endorsing, but he says this: moving to the point of looking at the extent of the green gap land, I believe that in general the council is right to avoid the trap of looking in detail at the edges of the built-up areas. It'd be too easy to allow those edges to be nibbled away, eroding the extent of the gaps and through a cumulative process eventually negating their purpose. And then this: the width necessary to achieve adequate separation is a matter of judgment, and I see no benefit in a detailed analysis of the boundary unless there is a specific identified need to do so. For example, if it were not possible to meet the CRSP, that's the Cheshire Replacement Structure Plan housing provision. Now that plan was till 2011. So in 2014, we know that the plan had reached the end of that date. The local plan inspector had specifically highlighted further need out with the structure plan requirement, which might be a reason for reviewing the green gap. they are inextricably linked. The green gap is undoubtedly affecting the housing supply in Cheshire and Nantwich. And the very inspector who endorsed the policy of green gap is the one who's recognising and identifying that it is a policy that might need to be reviewed in circumstances where there was housing need. It was equally, if not more, forced to the thinking of Mr. Boylan when he was faced with that situation in 2014, that had gone past the development plan period. And so it wasn't just within the confines of extra need from the Cheshire replacement plan up to 2011. In 2014, we were feeling around in the dark, or the inspector was feeling around in the dark, with the council not identifying the needs which needed to be met. And further proof in my submission of that close relationship between the extent of the green gap and the housing needs came in the form of the council's actions in another way. Your lordships have not been greatly impressed by my suggestion that the council were releasing sites for planning permission in the green gap, but they were doing more than that. The council were themselves progressing an emerging local plan, as they still are, and in that emerging local plan, to address present housing needs, they themselves had identified sites in the green gap. So they recognised that the green gap was constraining the supply of housing and were themselves proposing allocations in that green gap. Mr. Boylan, the inspector, with all his 25 years of experience, sat in that inquiry and 4 years after the plan period, 3 years after the plan period, recognised that the council's answer to the lack of 5-year land supply was to allocate sites in the green gap. And he himself specifically records that at paragraph 35 of his decision. He says the council are proposing housing allocations for the emerging plan in the same green gap. The inspector, my learned friend, would wish me to read the rest of paragraph 35, so if I may just take that up. Mr. Boylan's decision is in Appendix 1, paragraph 35, at page 54. He says this: however, since the inner boundaries of the green gap are also formed by the settlement boundaries, the consideration that policy NE2 also pertain to this policy in this respect, significantly, 2 of the housing sites identified in the emerging, that's the plan that's about to be adopted later this year, the Cheshire East Local Plans, more acronyms I'm afraid, but CELP, are in existing designated green gaps around Crewe. Although they're not in the vicinity and different considerations might apply, at this stage it cannot be assumed that the appeal site will remain outside the defined settlement boundary in the plan. When finally adopted, in this respect I consider any for also not up to date, because here was this difference between in an emerging plan situation, the council recognising that to address the housing supply it needed to release sites in the green belt, but denying the very same thing in a section 78 planning appeal, denying there should be any release of sites in the same designation. It doesn't matter that they're in a different part of the gap, it was still the same policy designation. I mean, one has to ask, how on earth could the inspector give full weight to policy NE4 if the council itself was releasing housing sites within it? And in truth, in my submission, paragraph 49 is nothing more than an articulation of common sense. Housing needs were not being met. Green gap sites were being proposed. It is a policy for the supply of housing. And the council knew that itself. If I may just skip over a few submissions to save time. I would just observe that in terms of the boundary, the inspector observed that NE2, which the council had conceded at the inquiry, was a policy for the supply of housing, was very similar to the policy NE4. It is just worth perhaps taking up NE2 just for a moment, if I may. my lords, it's in the core bundle. Sorry, it's in the Appendix 2, my mistake, Appendix 2, page 494, or MS 749, 494.
Yep.
My lords, you can see the title is Open Countryside. The council, I readily accept they have a different view here, and your lordships will say, well, this isn't necessarily assist with our interpretation, but certainly the council at the inquiry were accepting that this was a policy for the supply of housing within the natural environment chapter of the plan. And we'll see that all land outside the settlement boundaries defined within the proposals map will be treated as open countryside, thereafter to prevent development. Mr. Boylan's observation in paragraphs 34 and 35 was simply that it was very similar. The Green Gap policy was very similar because it was restricting housing in the same way. So again, a clear relationship between the supply of housing and policies NE2 and NE4. And if I may say so, my Lord Gill rightly observed that the narrow interpretation favours the local authorities, but that wasn't, of course, always their position. Cheshire East accepted NE2 was a policy which fell within this remit at the inquiry. And there's a further observation from Mr. Sitch's proof of evidence, which is quoting a council committee report. Might I just invite you very briefly to turn up Appendix Part 2, page 353, MS 604.
Did you say 353?
353.
608, sorry, MS 608 or 353 in the hard
Thank
copy.
you.
I don't have the time, and I would not wish to trouble your lordships with the discussion in the proof of evidence about this. Can I just direct your attention to paragraphs 1155 onwards? An inspector prior to Mr. Boylan had found that these two policies were policies for the supply of housing. And then just to go back a page to page 351, back 2 pages, 351. Sorry, just turning the page, I mean. And paragraph 1142, this was the current council's current stance in May of 2014. The council had said countryside policies in existing local plans can be considered as consistent with the MPPF and not housing policies, so they made that position clear, in as far as their primary purpose is to protect the intrinsic value of the countryside, in accordance with paragraph 14, and thus not out of date. However, and I just emphasise these 4 lines, however, it's acknowledged that where the council cannot demonstrate a 5-year supply, they may be out of date in terms of their geographical extent, in that the effect of such policies is to restrict the supply of housing. Now, that was precisely what fell within Lord Justice Limblom's definition. If they restrict housing, and here was the council accepting that those policies restricted housing. As far as the Green Gap is concerned, I'm going to pass over that. Your lordships have plenty of that. Just briefly, Res 5.
That was a council officer's, a planning officer's report to the council.
Yes, my lord, yes, yeah, had that status, yeah. The council say that this is not a policy for the supply of housing as well. I understand that to be their case on Res 5. Just for your note, although I don't ask you to turn it up, it's Authorities Bundle 4B, tab 50, MS 2314. This was in the housing chapter of the plan. It was about housing. Council denied that it was a policy for the supply of housing. The inspector deals with this in his decision at paragraph 55. Paragraph 38. Paragraph 38, page 55. Page 55. Paragraph 38. That decision is in Appendix 1. Appendix 1, page 55. paragraph 38 or MS 310.
Thank you.
And, my lords, just one word in that paragraph to notice, which is at 38, in the fourth line, he identifies that what was relevant here was the geographical extent of the policy. So when talking about whether policies are policies for the supply of housing, there's a geographical dimension here as to its restriction. May I then turn very briefly in the last 5 minutes to the issue of the literal interpretation. Lord Justice Lindblom, at paragraph 32, may I just invite you to take that up in Appendix 1. Paragraph 32 is on page 16. So, Appendix Part 1. Paragraph 32, he deals here, his Lordship deals here with the meaning of the words. Now, what Lord Justice Lindblom, here we were debating in the Court of Appeal the words. The one thing I'm afraid none of us did, those of us who were there in the Court of Appeal, is in wondering or contemplating what the words meant, we didn't pick up the dictionary. Lord Justice Lindblom did pick up the dictionary, and you have the relevant extracts provided from the second edition, which he refers to in paragraph 32. May I take your lordships to the word for, and just at the bottom...
Is this really?
Okay, but
Is this really helpful?
my lord, it's just...
It has 12 different possible meanings.
Yes.
Can it could mean the word a and the? I mean...
My lord,
You sort of...
He drew some comfort from the fact that it includes in the second definition affecting. So I'm simply.
It can do in certain contexts.
Yeah.
And in my respectful submission, with all the contexts that I've just explained in the first 4 points, that was not an unrealistic interpretation. It was, in fact, in the proper context, the most appropriate. The most appropriate.
Well, this is point in paragraph 32 at the end.
Lord, sorry, may I just respond to that?
I mean, this is the Lord Justice's construction
Yes.
of the relevant bit of a relevant dictionary.
The first meaning is in support of or in favour of troops who had fought for Napoleon. But I mean, if you ask which troops affected Napoleon, it would have been the British troops as well as the French troops.
My
So,
lord,
I mean, you can have it either way.
Yes.
My lord, I suppose my only point on this would be, here is a word which he describes as a versatile preposition. It does have a number of different meanings, that's
Right.
clear. And within the proper context of all of the first 4 points I've made, it makes perfect sense to see it as a policy for the supply of housing, precisely because the context shows the intimate relationship between the Green Gap policy, the countryside policy, and the wording, but I take it no further than that. As for the wider interpretation that the respondents suggest, in my submission, there's a geographical dimension to this. It plays its way out in the on the ground, and the policies push in opposite directions. It isn't said to be, by any of the respondents, a trump card. That was the appellant's submission that suggested that this policy is a trump card, and I make no further submissions on that. The narrow interpretation I've dealt with already, that it would have the peculiar consequence of finding out only the housing policies out of date, the very ones that are provided for. In the intermediate interpretation, I say nothing more on that. Conscious of the time, your lordships have in the grounds of appeal, which are contained in part 1 at page 117, the grounds of appeal submitted by Richborough Estates for permission to appeal. There were, as my Lord Conworth observes, contradictory decisions, not helpful to inspectors, pushing in different directions, and at paragraphs 5 to 11, the contradictions that are inherent are set out there. So paragraph 5 in particular without me needing to do it now, sets out all the different interpretations that have been given by the various judges of the High Court, and in particular, all of those authorities are in volume 1 of the authorities. All the paragraph numbers that are relevant are contained. So the Richborough Grounds of Appeal on page 118 in Appendix 1. 118 in Appendix 1. All the paragraph numbers are provided there. The contradictions are alluded to there. All of those cases are in the back of Authorities Bundle 1. On the issue then finally of discretion,
Yeah.
Mr. Kingston conceded 2 times yesterday that the outcome would have been the same because, as both Lord Conworth and Lord Gill have observed, the Crewe and Nantwich plan plainly was out of date.
Yep.
Well, the point can be made in reply. Lord Gill asked my friend Mr. Kingston, who replied, Mr. Boylan could in fact have reached the same result in the interests of housing demand, and the answer was, this is true. It's no part of my case to argue otherwise. That route is available, and I would respectfully suggest that when one reads the inspector's decision, whichever route he took, the outcome would have been the same. Now, the issue of discretion was raised by Richborough Estates in the High Court, and it was argued by Mr. Honey on behalf of the Secretary of State. You'll see in the judgment at paragraph 61 that it was rejected by Mrs. Justice Lang. But if your lordships accept this submission that in my submission is made by Mr. Kingston, that you'd get to the same conclusion, then the decision, my client is the only client with a planning permission here, it runs out in about 6 months' time. It had a 3-month period for the submission of reserved matters. The result would have been the same.
Yep.
On issue 2, I have nothing further to add. And on the Secretary of State's discretionary powers, the only point I would add is that as far as other material considerations are concerned, what the national guidance does is 2 things. The national guidance seeks to assist in identifying that very broad range of material considerations.
Yep.
And they are very broad.
Yep.
And the second point is that when it says things like great weight should be given to the green belt, all decision makers can see at local authority or at inspector level or Secretary of State level that great weight is meant to be given to that. Boosting the supply of housing is important, and it all stems, national policy all stems from a need to ensure consistency in decision making so that all local authorities, all inspectors and the Secretary of State himself are all working to the same basis upon which emphasis should be placed on greenbelt or boosting the supply or any other submissions. Unless I can assist you further, and please forgive them for going over. Those are my submissions.
Well, that clock's slightly fast. Thank you very much. Thank you. Mr. Philpott.
Please, your lordships, I have, together with Mr. Honey, submitted a detailed written case, and in that, amongst other things, I've sought to encapsulate what we say about the facts of the individual cases and how any of the points of principle would apply to those. I'm going to try and avoid those matters, therefore, an oral submission. I'm going to also seek to deal with the substantive issues first,
Right.
and then deal with the court's question about vires and where the powers come from. Your lordship should have, with a yellow tab attached to it, a written note.
Thank
that
you, we do,
have
yes.
submitted this morning. Brief
Secretary of
written
State's
note.
note on powers.
Indeed, my lord.
Thank you.
And part of the reason for dealing with it at the end is not just because we say it doesn't make a difference to the substantive outcome, but also it hopefully gives your lordships at least perhaps an opportunity over lunch to look at it.
Thank you very much.
And to save time.
But the idea that it was prerogative power which doesn't seem to be supported by anyone here, but found its way into the agreed statement of fact. And where did that come from, do we know? I mean, it can't have been just...
Well, it didn't come from the submissions, at least the written submissions, which I've seen, Secretary of State, which were based on common law powers. It may be, as we have admittedly speculated in the note, that it is the sort of loose use of language as to prerogative power, which the textbooks acknowledge.
But is that what Lord Justice Laws? Well, we don't know.
We don't know. But I speculate, but that's the position that we maintain, is that it's.
Anyway, your point is, when it's dealt with in Wade and Forsyth, is that a loose use of prerogative could just about cover anything, but it's not a very modern use.
Strictly speaking, it's not prerogative, and
of course, in planning, I mean, this is clearly a complex statutory scheme, which frankly displaces anything which could be called a prerogative power.
Well, we acknowledge in the note, as you'll see, that because of the modern and statutory context of planning, it's not a situation where the classic concept of the royal prerogative would make sense.
So I mean, we don't really, I mean, it's helpful to have it, but we don't need to spend very much
Great,
time.
from a law. That's part of the reason for putting it in writing.
But your point is essentially that it's rather curiously acknowledged inferentially by the sort of sections that you identify in footnote 1 on page 3.
Yes, but it is acknowledged.
But there's no overriding provision like there was in the 43 Act.
Indeed. Indeed.
Very well, thank
But
you.
you say it's a common law power, then?
We do say it's common law power for the reasons we
You
give.
can't say that. Really.
What I'm saying is that that's what he is
That's what
saying
he
at the
said.
moment. He's still saying it in his note.
Yes, but
I'm not sure what a common law power is if it isn't a prerogative power.
when you have a statutory scheme as elaborate as this, that governs, I mean, it's like immigration. It's been held that you don't have any sort of prerogative powers.
We've sought to deal with the arguments in the note. I can come back
But
to
I'm
that at the
grateful,
end.
and I see you're citing me, so I probably said something similar.
The moment that you accept that there is a powerful policy element in national planning, the moment you accept that there's policy, then immediately the entitlement of the minister to issue guidance is quite clear.
But, indeed. And we say that, frankly, whether it is derived from an inference from the statute, or whether it comes from common law, or whether, for the reasons we identify in the note, it might be a bit of both, it doesn't make a difference, because either way, no one denies we've got the power to do it. And if it's an implied power, implied from the statute, because of the breadth, not only of the powers that the Secretary of State has as a supervisor and also as giving a steer in the plan-making process, but also because of the myriad factors that are involved in planning and planning policy, the implied power must be very broad indeed.
But I mean, I'm sure you must accept that it has to be subject to the statute, and where you have, I mean, it's clear that the policy is specifically fed into the development plan process, so that he could, they have to take it into account, and he can reject the policy if the plan if it doesn't take it into account. It doesn't have the same specific provision in relation to the decision making, and so presumably you would accept what the Secretary of State can't do is to displace or distort the statutory development plan.
Mm-hmm.
Well, my Lord, the way that we deal with this in the note at paragraph 15, and this is where we say that the choice doesn't affect the issues, and it's the final sentence of paragraph 15, whatever the legal basis of my client's responsibility for national planning policy could not lawfully be issued which countermands or frustrates the operation of the statutory scheme, which is the way it was put in the West Berkshire case, and that was not a contested issue. That was accepted.
I know, but then it slightly begs the question as to what the statutory scheme is.
Or what frustrates me.
Well, so far as the question of what frustrates it, I'm going to come on to that. And well, what I was going to deal with, hopefully, before the lunch adjournment, was two issues. The first is how development plan policies work together to form the supply of housing, which is a subject matter of the sentence we're trying to interpret. And secondly, consistency of the Court of Appeal's interpretation with the statutory scheme. So far as the first issue is concerned, the Court of Appeal said in paragraph 33 of the judgment, if I can just ask your lordships to take up, I've got it in the core volume, at page 272, MS 272, which in the internal pagination is page 17. Sorry, it's the bottom of paragraph 33, which comes at the top of page 272. This is part of the explanation of the Court of Appeal's interpretation. They say it reflects the reality that policies may serve to form the supply of housing land, either by creating it or by constraining it, that policies of both kinds make the supply what it is. And my lord, that is a neat, we say, encapsulation of a point which we develop in a little more detail in our written case at paragraph 76. But in essence, the points we make there are as follows. In making a plan, where land is allocated for housing, it is also necessary to have counterpart provisions which constrain the development of other land so as to ensure, amongst other things, that the housing allocations are taken up. And one can well imagine a situation where the housing allocations might be, for example, on brownfield land, which is more expensive and troublesome to develop. Well, you may allocate that land, but unless you constrain elsewhere, you won't achieve the spatial strategy. And both elements, therefore, are necessary to ensure that the housing supply policy works in practice. And that essential concept, well understood by those who operate within the town and country planning system, is the subject matter of paragraph 49. When my learned friend, Mr. Lockhart Mummery, took your lordships to the strategic policies of the Suffolk coastal plan, I don't need to take your lordships back there, but you'll recall how all of those strategic policies, from SP2 through SP19, and then to those policies which follow and amplify it in the terms of the policy, are inextricably linked. And they are all necessary and identified as necessary to form the supply of housing and to do that in a way which complies with the spatial strategy. And one can see at a glance from that, not only is it apparent that all of those policies on the narrow approach, SP19, through to the end of the SP policies which are identified within it, are relevant policies for the supply of housing, but that would include SP29, the countryside policy. And there is an artificiality in seeking to hive off the last part of the hierarchy, which is inextricably linked both in its definition and its function and its terms in restricting from those earlier parts of the hierarchy. It's artificial to separate it out. And once one accepts that the definition of policies for the supply of housing includes restrictive policies of that sort, then as the Court of Appeal itself made clear at paragraph 36, there is then no logical basis as a matter of legal principle or interpretation for distinguishing between restrictive policies of a general nature and those of a more specific purpose.
I mean, is there any difference in your position and what we heard from Mr. Lockhart Mummery?
Well, it is, because I go a step further, because I have to deal with a generality. Mm-hmm. And although in the instant case that Mr. Lockhart Mummery is dealing with, one can see that the countryside policy at the end, formed as that policy was in a relatively modern context, is clearly part of an interlinked set of policies. Once one accepts the principle but that restrictive policy is inextricably linked as part of the policies for the supply of housing in that plan. Once you accept a restrictive policy in principle, can be relevant policy for the supply of housing.
Well, then you go along with the Court of Appeal and say there's no logical starting point.
Indeed. And
yes, so I mean, your position, and so I mean, I'm not sure whether it is very different, but yours is very much the Court of Appeal's position.
Indeed. And the point about that is that once you accept it's not a distinction of principle, that's when it becomes a question of effect, whether its effect is to restrict the supply of housing in the way that the Court of Appeal anticipated. And the Court of Appeal made that focus clear in paragraph 35. And can I just ask your lordships to look at paragraph 35 of the Court of Appeal's judgment?
The opposition is essentially to accept the analysis of the Court of Appeal throughout, is it?
Indeed. But, my lord, at paragraph 35, and this is an important point, it is not all restrictive policies on the Court of Appeal's approach that would be relevant policies for supply of housing. As the Court of Appeal says, restrictive policies, whether broadly framed or designed for some more specific purpose, may, we stress, may, have the effect of constraining the supply of housing land. If they do have that effect, they may, again, we emphasise may, act against the government's policy of boosting significantly the supply of housing land.
I mean, what does that mean? Because, I mean, they've talked in the paragraph 33 about green belt policy.
Indeed.
I mean, clearly that restricts housing development.
Indeed. And in some cases...
What is there that isn't there?
Well, my lord, this is precisely the point, that because there will be some policies where it is absolutely obvious, such as Greenbelt, that it is having that effect. There will be others, say a policy that protects individual listed buildings in their setting, which is so specific and it's plainly not going to. But as to where you draw the line, it's not a matter of hard legal distinction. It becomes a judgment about where the effect to which it is having that effect.
The problem I have is, what as we've gone through all this, I mean, in a way we're just going over ground we've covered, but the green belt policy is inevitably restricts where you can put housing. And the Court of Appeal are saying to that extent it is a policy affecting the supply of housing. But to say that it's out of date or deemed to be out of date just because the authority haven't got a 5-year supply seems to be playing with language. And I find it very difficult, I don't know whether the author of this document is sitting behind you, but I certainly find it very difficult to believe that that would have occurred to him.
Well, again, I want to develop how that sits within the context of the MPPF in due course. But the short point, my lord, is that it has two effects, deeming it out of date. The first effect is that it engages the application of paragraph 14. The second effect, as we identify, is that in the context in which it is to be considered out of date, because of the absence of a 5-year housing land supply, the decision maker then has to ask the question, what weight do I attach to a policy which is considered out of date in those circumstances?
Again, we've been through all that. He has to treat it as though it was silent or absent.
Well, my lord, no, but with respect, my lord,
According to paragraph.
I'll come back to this in more detail in my second set of submissions.
Can I just ask you this? I mean, you're representing the Secretary of State, who presumably had a view of what this all meant when and indeed the whole purpose of it was to simplify and clarify everything. Before, which was the first decision where this all came up in court? Was it the William Davis decision? Or?
I believe that may be.
I'd be quite interested to see what was submitted on behalf of the Secretary of State at that time by Mr. Morici, I think it was.
I can check, my lord. But
because, and what sort of guidance do the poor inspectors get about it? Is there some sort of, because they have to deal with this on a sort of consistent basis in the face of varying guidance from the courts. Do they get any guidance?
I'd have to take instructions rather than answer that off the cuff. My lord, having identified as I have, that there's no in principle basis in terms of a hard and fast legal principle for distinguishing between different restrictive policies, that brings one straight into the territory of Tesco and Dundee, which is that this is a provision framed in language whose application to a given set of facts requires the exercise of judgment. That's paragraph 19. And what we say, my lord, therefore, is that in the example we have of the Suffolk coastal policies, an SP19, in a sense, is a neat encapsulation because it brings within its scope all of those policies which amplify it. It both encourages and, in hierarchical terms, distributes and restricts within the same policy. In one policy, it encapsulates the broad point that we make in our written case at paragraph 76, and it is an entirely typical policy approach. Lord, I want to turn on to the second issue now, which is the consistency of the Court of Appeal's judgment with the statutory scheme. And, my Lord, the Court of Appeal's judgment at paragraphs 42 and 43 correctly identifies how the framework, both in general and specifically in relation to paragraphs 49 and 14 in particular, fit within the statutory scheme for development control decision making. As a policy document, the framework does not and could not have the effect of displacing the statutory presumption. Its legal status is as a material consideration external to the development plan, and the framework we know says so in terms. The presumption in favour doesn't modify the framework, it operates within it. And the outcome of applying paragraph 14 in an individual case is a material consideration that may tell either for or against the grant of permission. The weight that is given to the framework is a matter for the decision maker, and the correct sequence of decision making is as set out in paragraph 43 and should not be controversial. And we say that sequence encapsulates the application of section 38.6 and the role of national policy within it, and remains now, as it ever has been, since section 38.6 and its predecessors are brought into force. The second point, my lord, is neither of the consequences of considering a policy to be out of date pursuant to paragraph 49 is in any way inconsistent with the statutory scheme. So as I identified, there are two: the policies that are to be considered out of date, although they would still apply, and secondly, the last bullet point in the framework, paragraph 14, would apply, subject, of course, to the footnote. But the key issue for these appeals, for the purposes of determining these appeals, is the effect of a wider or narrower scope of paragraph 49, and therefore the scope of the policies that would be called. And as we've explained in our written case, the width of the interpretation in any particular case wouldn't affect the question of whether paragraph 14 is engaged. If the narrow interpretation is adopted, paragraph 14 is still engaged simply by reference to a narrower range of policies, and still goes into the paragraph 14 tilted balance equation. In other words, the dispute as to the width is not about limiting the circumstances in which paragraph 14 is engaged or triggered, as the appellants put it in their case at 77. Because paragraph 14 is not said to be ultra vires, an ultra vires policy, there's no logical basis for suggesting that the words in paragraph 49 ought to be interpreted so as to confine its operation. It then becomes an argument about the merits or otherwise of the policy rather than its interpretation. And the key issue, we say, therefore, raised by the appellant's case is whether the effect of the wider interpretation, with a wider range of policies being considered out of date, is in any way inconsistent with section 38.6.
You say it's not ultra vires, but on the face of it, once you accept that the statutory scheme specifically includes development plans, and development plan says X in relation to housing, how is it open to the Secretary of State to do something which is inconsistent with what is said to be X?
Well, my lord, frankly, there's a distinction to be drawn between section 38.6 and having, in all circumstances, to make the decision in accordance with the development plan. It might be worth just going to the City of Edinburgh case,
Okay.
which is...
The situation, I think, is quite straightforward, is it not? Before the 1990 Act, you had to have regard to the development plan and other material considerations. no pronouncement as to weight of either. 1990 introduces the presumption in favour of the development plan unless material considerations indicate otherwise. But again, no specification as to weight.
Indeed.
And that's the starting point of the analysis of 38.6.
Indeed it is. It is.
I understand that, but...
My Lord, if I can ask your Lordship to go to City of Edinburgh, it's in the Authorities Volume 1, and it's tab 5, and the MS page is 1006. And at letter F, just above letter F, there's a sentence beginning, if the application does not accord with the development plan.
So material considerations can override the development plan. That's what I have slight difficulties with, I must admit.
There's no mechanical preference. There remains a valuable element of flexibility. If there are material considerations...
Which paragraph are you reading now?
It's in F and G.
It's F and indeed G. And at the bottom, endorsing what is said by Lord Justice Glidewell in Loop, what Section 54A does not do is to tell the decision maker what weight to accord either to the development plan or to other material considerations.
I wondered about that. Lord Justice Glidewell is one of the great experts on this, but why not? I mean, surely the whole point of 54A, now I sort of reminded of its existence, was to shift the balance.
Well, my Lord, what it does is...
Tell the decision maker to give more weight to the development plan.
It does not dictate the weight the decision maker should attach to the plan.
It says give more weight to the development plan.
But my Lord, it doesn't.
Priority.
It's a
thread and all that.
No, my Lord, the golden thread is the framework.
About the golden thread.
Which I'm going to come to.
It's priority. It must mean. I mean, this is what the Lord ministers were saying. The whole point is to give power back to the people, presumptions and whatnot. And it must mean that you've got to give more weight to the development plan.
Well, my Lord, the weight is classically in the judgment of the decision maker. And if I may say, one of the points that is acknowledged by the courts is that there may be more recent guidance which supersedes it or means that the plan is to be seen as outdated in that same section. Thus, the priority is not a mere mechanical preference for it. The weight must necessarily be sensitive to those questions.
My concern, I must say, goes deeper than that. It is perfectly right to take to what Lord Clyde says, because my concern is really inconsistent with what he says. But as a matter of normal principle, forgetting planning in particular, if a statute says you have to take into account the contents and principles contained in a particular document and all other material considerations, it seems to me a bit rum that the other material considerations can be something the Secretary of State has no statutory specific authority to do, but just says don't take into account what effectively it's contradictory to the plan which you're required to take into account.
Well, my Lord,
normally, as a matter of statutory construction, you'd assume material considerations were things which added to what was in the document you were specifically required to take into account, not something that actually undermined something in that.
My Lord, with respect, not at all. Because if a development plan has been superseded by more recent guidance, or indeed, there may be...
Yes, I know you say that, but where do you get that from? It's a fundamental constitutional principle. Parliament has said you have to take into account what's in the document and all other material...
Then it all depends what's in the document.
Well, if what's in... Yes, I know, but if the material...
If what's in the document is entirely flexible, then there you have it.
Yes, but if they say no housing other than here, or maximum of so and so much housing, I have difficulty with the notion that other material considerations can be inconsistent with that.
Well, my Lord, if I can just briefly on that point, because, and I've asked your Lordship to look in due course at relevant parts of what's said in Alconbury about the importance of national supervision and national policy in this context, because the local, in terms of planning, is not in some way distinct from the national interest. The Secretary of State has a national interest which is made up of the collection of local authority areas. and therefore they can't be in splendid isolation. And the system, section 38.6, does not say anything other than the determination must be made in accordance with the plan unless material considerations indicate otherwise. That flexibility is essential to cope with the myriad circumstances which arise in town and country planning, which may be changes of policy, it may be changes of fact, maybe changes of legislation since the plan came into effect.
What you can say in answer to me is that the House of Lords have said this on more than one occasion, and we've had statutory provisions since then, which could be assumed to proceed on the basis that what the House of Lords has said is the case. I do find it, if we were starting with a blank sheet, I would have considerable...
Do we have the loop decision?
Yeah, we do.
Where is that?
I'm just going to... (2A) tab 21, my lord.
Thank you.
I'm conscious of the...
Yes, I'm sorry.
Of the time.
But quite
If
important
you
that
wanted
we...
to deal with it now.
Yes, I appreciate it in encroaching on your time, but... Yeah, we are...
Why don't we have a look at it over lunch? Indeed.
Is that convenient? Would you like to? You've got another 2 minutes if you want it. According to my clock, anyway.
Let me just see, my lord, if that's a convenient point.
If you need to look, probably we're better adjourned.
I think probably if I resume where I was going to be after lunch, it might be neater.
And I'll try to ensure you're not interrupted too much, but thank you. Very well, we'll resume again at 2 o'clock. Court's now adjourned.